The big story this week is the shakeup happening at ATF. Last week, Attorney General Bondi fired ATF's General Counsel, Pamela Hicks, a 23-year veteran of the agency. Taking to LinkedIn, Hicks posted a short note about her recent job loss. While she didn't give the reason for her termination, it does follow a trend of the Trump administration cleaning house in various agencies falling under the DOJ. I should also mention that during Trump's first administration, Hicks served as the deputy chief counsel. However, this departure may serve as good news for gun owners because at the ATF, the general counsel is tasked with implementing gun laws passed by Congress. So they're not really our friend unless you like gun laws. Attorney General Bondi also raised an interesting point during a Fox News interview that may have played into Hicks being shown the door.
Yesterday, I fired the general counsel from ATF. These people were targeting gun owners. Not going to happen under this administration.
Sounds good, but will she stick to her word? Well, actions speak the loudest, but that's a good start. Assuming we take the Attorney General at her word, the next 4 years might mean that ATF will be less likely to implement new regulations targeting law-abiding gun owners. This begs the question, and it's an important one, who will be the incoming General Counsel? But that's not the only change at ATF. For those who recall, ATF Director Dettelbach resigned on January 18th prior to Donald Trump taking office, leaving the agency without a confirmed director. And over the weekend, it was confirmed that Trump tapped Kash Patel, the new director of the FBI, to take the reins over at ATF as its acting director. Now, John actually interviewed Kash before the election, and there's a link down in the description, so go watch that. So what does this mean for the agency? Well, if Patel's plans for FBI are any indication, it might mean some positive changes are inbound at ATF. Perhaps we'll see less aggression towards gun owners and FFLs and more action against actual criminals. Welcome back to the Big 2A, the show where we bring you all the top 2A stories. I'm your host, Adam Kraut, and I just want to thank you guys for watching the first episode. It was nice to see so many of you were happy to have me back. If there's something specific you want us to cover on this show, drop that down in the comments. We've got a lot more coming, so let's get to it.
Adam's back. Yay, nature is healing.
Last time I told you we'd be keeping an eye on colorful Colorado, and as promised, here's your update. The state Senate significantly altered the pending assault weapons ban legislation to gain the support of the governor. The bill no longer is just a flat ban like it once was. It requires a few hoops to jump through to exercise your constitutional rights. That's right, now, in order to obtain any of the firearms that are banned by the bill, there's 3 things a person can do. First, they can complete a hunter safety education class and a basic firearm safety course, or they can complete an extended firearm safety course, or pulling up the caboose on this list, they can do the extended firearm safety course more than 5 years before the purchase and the basic firearm safety course within 5 years of buying the guns. For those first 2 options, it's worth noting here that that course has to be taken within 5 years of the purchase. So all of you in Colorado, you're taking a class whether you need one or not every 5 years if you want one of these guns. And that's stupid. Now, you're probably asking, but Adam, what's this trash about being required to take a class? Here's the gist. For either the basic firearm safety course or the enhanced one, the instructor must be verified by the sheriff, the class must be in person, a fee must be paid. There's a lot of musts here, you getting this? The person also has to hold a firearm safety course eligibility card, and a test has to be administered where the person needs to score 90% or better. Oh yeah, the basic course is at least 4 hours long, and that extended one's at least 12 hours over 2 days. So talk about your time commitment. And let's not forget that firearm safety eligibility card I mentioned, it just requires that you go to the sheriff to get fingerprinted and pay a totally different fee before you can even get to the classes. This bill is now sitting at the State House after being passed out of the Senate with a 19-15 vote. The process is the punishment in this case. And it begs the question, as an alternative to an outright ban, do you think we're going to see blue states implementing this ridiculous licensing requirement as a way to discourage ownership of these types of firearms? And what about those additional financial burdens being placed between you and the exercise of your rights? Let me know what you think down in the comments below. In other news, the courts have once again been on fire with 2A wins, and boy do we have a lot to cover. Let's start with another ATF loss, yay! Coming from a lawsuit by Franklin Armory and the Firearms Regulatory Accountability Coalition, better known as FRAC. John's laughing, I'm laughing, we're all laughing.
Yay!
Back in 2017, Franklin Armory asked ATF to assign a classification to their new firearm, the Reformation. Notably, that gun had a unique barrel design, that being the barrel had straight lands and grooves, not the ones that spiraled. So it goes like this instead of like this. I suppose you could say it was interesting. Now, ATF ultimately determined that the firearm was not a rifle, but was a shotgun under the Gun Control Act.
What?
Why? Because the ATF said this design was a smoothbore. Now, bear with me here, this gets off the beaten path. Because the lands and grooves didn't spiral, it wasn't rifling. However, ATF said that a smoothbore didn't actually have to mean that it was completely smooth, just unrifled, so no spirals, which is how they got to shotgun, at least under the GCA. However, the National Firearms Act definition of shotgun requires that the gun uses shotgun shells. One small problem, the Reformation was chambered in 300 blackout. Told you this was a mess. So, since it couldn't be a shotgun under the NFA as well, ATF classified the firearm as a GCA-only regulated short barrel shotgun. Then ATF told Franklin Armory it could only be sold to those who had FFLs and not taken over state lines, while it created a new form that it never created before going back and just telling them, hey, we're actually kidding, it's not legally or practically feasible to permit the transfer or transport of this GCA-only short barrel shotgun outside of the requirements of the NFA. Basically, nice short barrel shotgun you have there. Told you it was confusing. To muddy the waters more, Franklin Armory also introduced a gun called the Antithesis in 2020, which uses both shot shells and cartridges, but had a rifled bore, the kind that goes like this. ATF classified this as a short barrel rifle based on the objective design features of a rifled bore, namely that it's designed to fire a single projectile, not several. So, naturally, ATF got sued.
We are gonna sue you!
Franklin Armory and FRAC argued a number of points, but here's what you need to know. The court found ATF exceeded its authority in defining smoothbore as anything lacking functional rifling, and ATF also exceeded its authority by not giving the plain meaning to shotgun shell and reclassifying the Reformation as an NFA-regulated shotgun. With the Antithesis, the court found Franklin Armory designed the gun to fire multiple kinds of ammunition. So it doesn't only fire a single projectile, but rather multiple ones, which is not incidental or a byproduct. ATF once again exceeded its authority by not giving plain meaning to the words of the statute. The remedy? Vacature or throwing out ATF's classification. So the Reformation is now again a GCA-only shotgun, and that other gun that I'm really tired of saying its name remains unclassified.
Antithesis.
Yeah, that. The court also ordered ATF to create GCA-only procedures for the Reformation within 180 days of the order. Moving on, a Trump appointee in Maine has preliminarily enjoined the state's 72-hour waiting period to obtain a firearm, and for those that don't remember, that means the law is blocked from enforcement during the time the underlying lawsuit is being litigated. So that means for now, anyway, that 72-hour wait period, no good. The state's attorney general took this weird position that the right to keep and bear arms doesn't include the ability to acquire them. That's really actually kind of an interesting take, and last I checked would render the right meaningless, but okay, whatever you say, boss. Fortunately, the court disagreed with that assertion, finding that acquiring a firearm is a necessary step in the exercise of keeping and bearing a firearm. Any interpretation to the contrary requires the type of interpretive jujitsu that would otherwise make Kafka blush. In other words, the judge called bull. The court applied the test spelled out in Bruin, finding that acquiring a firearm falls within the plain text of the Second Amendment.
Damn right.
And that any historical analogs proffered by the government fell short of justifying the 3-day waiting period as being consistent with the nation's history and tradition. Now, the state pointed to laws relating to background checks and disarming drunk individuals as historical justification for waiting to get your gun, but the court didn't find those arguments persuasive. It said that the how and the why of those laws did not align with the how and the why of the waiting period law. In other words, those analogs weren't really analogs at all. So, what did the court find? The court found that Maine's laws sweep too broadly and did not apply a narrow, objective, or definite standard to justify disarming individuals. It just applied to everyone at large, rather than a specific subset of facts relating to the individual purchasing the firearm. In my personal opinion, it's very likely this case will end up in favor of gun rights, at least at the district court. This is another one we're tracking. Oh, by the way, you remember when Maine was considered a free state? I think Pepperidge Farm remembers. And let's not forget about our dear friends in Illinois. Recently, a judge struck down the firearm owner identification card as unconstitutional for the third time in this SAF and Illinois State Rifle Association supported case. This whole thing stems from the prosecution of a woman who, back in 2017, became fearful of her husband and left him. In turn, what did he do? Well, he went to the police and filed a complaint stating that she had shot her rifle in the home. So the cops showed up, and they ultimately found that she did have a .22 rifle, but it had not been fired. That didn't stop them from prosecuting her anyway, and they prosecuted her for possessing the firearm without a FOID card. Notably, she was eligible for the card, she just didn't have one. So, remember, in order to possess a firearm in Illinois, an individual must have a FOID card. That's right, Illinois requires you have a permit to possess a firearm inside of your own home, which is what I thought the Second Amendment was for. But what did the trial court find? Well, as one might expect, in applying a straightforward Bruin analysis, it found that her possession of the rifle in her home for self-defense was squarely within the ambit of the Second Amendment's text. Looking to the government to produce a historical analog that would justify the modern restriction of a FOID card, the court found the state coming up, well, let's call it short. Additionally, the court found that administrative fee associated with the FOID card, at least as it relates to having a firearm inside of one's home, to be an unconstitutional burden. However, before all of you in Illinois go rushing to possess firearms in your home without a FOID card, just keep in mind this one little thing. The state's fighting this, and they want you disarmed. Now, this case has been to the Illinois Supreme Court twice and is headed back for a third go-round, where finally that court might actually be forced to address the constitutional issue head-on. And that would be great news for gun rights.